Well, the definition depends on the type of DUI. There are, I'd say, essentially three types of DUIs or charges that could be brought, although they kind of overlap in some cases. The most subjective one, the most subjective one is 23-152A, which is proven by proving impairment. Being under the influence, that's the way the statute's written. It actually says, it is unlawful for a person who's under the influence of any alcoholic beverage to drive a motor vehicle. 23-152A used to incorporate drugs back in the day, but now there's a new charge, 23-152E, which takes into consideration drugs. It's essentially the same wording. It's still subjective based on impairment. The basic standard for under the influence means that your physical or mental abilities are impaired so that you can no longer drive as well as a normal, cautious, sober person. It's subjective. That's why officers want as much evidence as they can get to try and sway the DA and the jury that you were impaired or more impaired than a reasonable sober person. 23-152B is being .08 or higher, alcohol related, and there's a presumption that kicks in on per se DUIs. What I mean by that is that if you're .08 or higher on a valid test within 3 hours of driving, you're presumed guilty, not just of 23-152B, but also guilty of 23-152A, which means you're impaired. And then that really does shift the burden in many ways to the defense, which makes it harder to win. In this state, in most states, for most drugs, there is no per se limit. It's basically the presence alone of a drug or the amount of the drug don't necessarily give you any kind of presumption of guilt. It doesn't prove anything, but yes, forensic experts can basically look into the evidence or into the blood test when you do what's called a quantitative analysis and determine that you had a level that was either a therapeutic level or above, and that can affect the proof. But it really comes down to observations of the officer. Officers think they know everything when they come on the scene, and sometimes they don't ask the right questions, but they'll pick up on everything they can. They've been trained, and they tend to sway the balance a little bit towards the prosecution because they kind of assume that they know whether the person's guilty or not. So those are the three basic charges for DUI. If you have a combination, let's say alcohol and drugs, depending on the drug and the levels, and you could say be .06 or .05, somewhere in there, and combined with alcohol could cause more impairment. Those cases are tougher in a lot of ways, depending on the evidence of the driving. How good was the driving? What were the observations on the scene? Did the person do the field sobriety test? Did the person, what testing came out? So those cases can be more complicated because even forensic experts, it's almost like an X factor in that you're combining these two substances. Same thing with marijuana. If you combine it with alcohol, it's real tough to defend because anything the officer says could be true unless you have other witnesses or you have something on videotape, which is sometimes that can help. That's kind of where those are at. So those are the three basic charges.